Hello, my name is Nate Cade. I'm an associate attorney here at the Green Law Group, and today we're going to be talking about some steps you can take to protect your contractor's license. Here's our sponsors for this event. We'd like to thank them. Just before we get started, everything I want to talk about today is just general kind of legal discussion. It's not legal advice. For legal advice, it would have to be tailored to your specific scenario. You know, the facts of every case are different. So for legal advice, you know, you would have to, I would encourage you to consult with a construction attorney if you have any issues that come up. But today we're going to be talking about things that anyone with contractor's license should be aware of and can do to make sure that they don't lose their license, because the consequences of contracting without a license, as we'll see, can be catastrophic. So a little bit about our firm. Scott Green is the managing partner here. He's been practicing law since 1978, and he's primarily focused in construction law his entire legal career, and he comes from a family of contractors as well. I've had the opportunity to work here just over 4 years now, and our firm also does employment law, which of course contractors have employees, so they need those resources as well. So I've done some employment law here, and now I primarily focus on construction defect and payment disputes. And we have 7 attorneys on staff right now, and I have one more joining us soon as well. She's a law clerk here now and just got her bar results. A little bit about myself. Personally, my background from a construction standpoint, in my teenage years, I spent a few summers swinging a hammer, working as a laborer, doing some roofing and framing. Later did some hardscaping as a laborer for the better part of a year. Got to learn how to drive a Mini X and push dirt around. Then I worked for Anne Arundel County in Maryland, is where I grew up. I worked for the Department of Public Works in wastewater operations, and then eventually became the operations liaison for all of our capital upgrades. So I served as the operation liaison on several multi-million-dollar utility construction upgrades before I left wastewater to pursue a legal career. And I started here while I was still in law school, and I've been here, like I said, just over 4 years. So construction law is my thing. I really like it, and glad to have this opportunity to hopefully refresh your memory or teach you something today. So I've kind of broken this webinar out into 3 parts. Basically, the first part, what to do when you're doing work. The second part, dealing with subcontracting. And even if you are a subcontractor and you never hire any subs, there's probably some information there that you can benefit from. And then the last segment is, well, what, when things go bad, when there's a dispute, what actions you can take to minimize your liability. So obviously have the right license for the job. It goes without saying. I mean, you should know, if you have a C class, you should know what the description of the work that you're able to perform is, and of course, incidental work to that. But even for B contractors, you might think, hey, I'm a B, I can do anything as long as it's 2 trades or more. Well, they have to be 2 unrelated trades, which, so if you're doing foundation, is excavation and foundation unrelated? Probably not. So that might just be, 1 trade. And if you're a B, you would have to, hire a specialty foundation subcontractor. If that was the entire scope of the project. Also, even when you're a B contractor, there's certain trades that, you have to subcontract out or have the C classification yourself, C53 for swimming pools, and then of course asbestos remediation. There's only, I think, 4 types of specialty contractors that are able to get asbestos remediation certificates. Of course, a B contractor can get an asbestos remediation certificate. And then there's C22, which is a specialty classification just for asbestos remediation. But this is something that even I actually had a client who didn't have the C22 specialty. They had a B license, and they ended up doing a project that included some asbestos remediation. They called inspectors. They got the testing done by people with asbestos certification, but the actual remediation work themselves, they performed in-house, which was bad news because they didn't have the asbestos certification, and they ended up having to write off $45,000 for that project, even though just a small portion of that probably of that money was attributable to the actual remediation work. So it's important that you make sure you have the right license for the job, and if you're going to have to hire specialty licenses for particular scopes. If you're ever in doubt whether you're allowed to perform certain work based on your license classification, you can always call the CSLB hotline. I think it's 800-321-CSLB is their phone number, and you can ask them. Just remember that the CSLB is not there to help contractors. It's primarily a consumer protection agency protecting the owners from unscrupulous contractors. Here's another one that, surprisingly, there's an issue that comes up a lot where we see contractors, I've seen clients doing it, I've seen opposing parties doing it, where they don't have the right name on the contract. I recently got a judgment against a contractor who had not paid my client as a subcontractor. And that the prime contractor, his contracts had an LLC, but the licensed entity was just the individual. So by taking the money in the name of the LLC and contracting with the LLC, that contractor was actually contracting without a license because only the individual was licensed. In 2007, the Court of Appeal upheld a decision prohibiting a contractor from pursuing collection on his unpaid invoices. Again, it was a situation there where he had a Montana corporation. I don't know why, maybe it was tax advice, but it wasn't the construction attorney advice that caused him to form a Montana corporation and start contracting in California with it when the president owner, he was the sole owner of the corporation and he was licensed, but the corporation was not. So the court ruled that he could not pursue collection of his unpaid invoices. You might not think about this when it comes to maintaining your license, but if you're a corporation, you have to maintain your corporation as well. If your corporation is suspended from conducting business, and there's a chance the CSLB could find that your license was suspended as well. So conduct corporate meetings at least annually, keep corporate minutes, keep up with your statements of information with the Secretary of State, and of course taxes. Pay your taxes, and the Franchise Tax Board. If you have a problem with them, they will notify the Secretary of State, and your authorization to do business in California will be suspended. Make sure you provide updated contact information to the CSLB, the Secretary of State, and the Franchise Tax Board. If you move offices, change phone numbers. If you're a corporation, if you add officers, remove officers. Anytime you make a change in your corporate status, you want to make sure that everybody is updated with the latest information. So here's a big one that, sometimes things can just slip through the cracks and you can find yourself without a license. So it's not just renewing your contractor's license, but there's other things that go along with that. Obviously, to have a contractor's license, you have to have a license bond on file with the CSLB. So if you say you're licensed, you're like, oh, I'm good, it's not till July of 2022, and you forget about your bond and your bond expires, well, then the CSLB will suspend your license because you didn't have a license bond. So keep track of the key renewal dates, your contractor's license, your license bond, your workers' compensation coverage. And then I put general liability coverage on there with an asterisk. And that's because, if you're a sole proprietor, you're not required to have general liability insurance by the CSLB. Of course, it's not a good idea to be working without general liability insurance. The liability that you could face if, a building fell down, worst case, you know, it's just tremendous. So, you know, you want to have the right coverage, and keep track of those renewals. It's always a good idea to calendar multiple reminders, say 60, 30, and 60 and 30 days out, and then maybe a final 1-2 weeks out to make sure that you've done everything you need to renew your license, your bond, and your insurance policies. Another thing you can do is maybe do it quarterly or every 6 months, have a reminder set to just go online and check your license status on the CSLB website. It takes about 30 seconds, just to make sure that you didn't miss any piece of mail from the CSLB that could impact your license status. So the consequences of not having a license, if you don't know by now, are pretty severe. Business and Professions Code 7031 has 2 parts, basically. Part A says you cannot pursue collections for construction work if you weren't licensed at all times during the course of the project. And then Part B says that the owner can then sue the unlicensed contractor to recover all the money they paid. So you can see in 2005, there was a project. It was several months or over a year-long project, but at the very start of it, the contractor was unlicensed and then got their license 18 days into the project. The court ended up ruling that they could not pursue over $1 million in unpaid invoices based on that 18 days at the start of the project that they weren't licensed. Another thing you want to do is use lawful and fair contracts. I put fair in quotes because there really is no such thing. The world's not fair. But when it comes to construction, especially when you're directly contracting with owners, there's certain requirements and disclosures that you have to have in writing in your contracts. For home improvements, these home improvement contracts, these regulations are pretty substantial. And in a minute, we'll look at a sample home improvement contract. But even on commercial contracts, there's still a requirement that the contract includes a paragraph notifying the owner about the CSLB's regulation of contractors in the state of California. So home improvement contracts are, pretty tricky. So I'll look at one here. So Business and Professions Code 7159 has a lot of different requirements of everything that has to be in a home improvement contract. And I have templates that I'll give my clients, and I'll hear, Nate, this is too long. My customers don't want an 11-page contract. So the document we're looking at right now is 11 pages. You'll see at the bottom, it's page 1 to 7. There's another 4 pages of attachments, and all 4 of those pages have to be there. It's required by law when you're directly contracting with the owner of residential property for a home improvement project, any work on a residential property, home improvement, you have to have these disclosures. So in this template that I've had, and this will be made available as well, every provision that is required by law to appear in the contract is highlighted. So you could even, take this highlighted version and you could show your customers, because your customers, they don't want an 11-page contract, but you could show them the highlighted version, and you can explain that most of these provisions are there for their protection, and everything that's highlighted on this copy is required by law to be in the contract. So when it comes down to it, pretty much everything on the first page here is required by law. Practically everything on the second page, you have to have and the law is very specific. It says what font size, it has to be in bold, it has the exact language for your headings, like the labor and or services to be performed and or material and or equipment to be supplied. That's the exact language in the law that says you have to have that heading on your description of work. You can attach an addendum for your description of work. Typically it will be attached, rather than writing in the 5 lines that I have on this template. But again, almost everything on the second page required by law. These are notices to the owner telling them that they have certain rights. Almost everything on the third page required by law, and about half of the 4th page. So, well, let me explain. I highlighted this middle portion here under arbitration. That's it's not required to have an arbitration agreement in your contracts. We highly recommend that you do have an arbitration provision. But in a home improvement contract, if you're going to have an arbitration provision, this middle portion here that's highlighted is required by law for the arbitration provision to be enforceable. So you have to have a separate initial box rather than the main signature line. You have to have this notice that they're giving up their right to a jury trial. It has to be in 12-point bold font. So these are all detailed requirements that the law requires when you're doing home improvement contracts. So when it comes down to it, and you could show your customer the highlighted version to explain, when it comes down to it, there's really only about 2.5 pages of terms and conditions that are not required by law. The last 4 pages, the attachments, you have to give them a notice of the right to cancel. Now here's a 3-day right to cancel. There were some updates to the law this year for people over 65 years old. They have a 5-day right to cancel. So, and then that's the notice of the right to cancel. And then separately, other attachments is the actual cancellation form. So here you would fill in your company's name and address, fax, and email that they could send it to. You fill in the date of the contract at the top, and then you leave that attached to the contract without the owner's signature. If the owner wants to cancel within 3 days or 5 days if they're over 65, then they sign it and they send that to you. So obviously the best thing to do is to make your start date at least 4 days or 6 days after your contract date, so that that cancellation period has expired before you start working on the project. And you have to have 2 copies of the notice of cancellation. And then the last required attachment, you have to have a sample change order form attached to your contract. That's what the law is. So out of this 11-page contract, there's only about 2.5 pages of terms and conditions that aren't required. So if you can explain that to your customers when you hand them an 11-page stack of documents, you know, that might make things easier for the customer. So another thing with residential projects on swimming pool contracts have extra requirements that aren't in regular home improvement contracts. You have to have a diagram of the pool attached to the contract. So, you know, if you have questions whether your contract is compliant with the requirements, depending on the type of work you're doing, you know, I highly recommend you consult with an experienced construction law attorney, either myself or someone here at our firm or your firm of choice. But, you know, we do construction law, so I have these templates, and, you know, it's something I work with on a day-to-day basis. Now, maintaining workers' compensation coverage. If you have employees, you have to have workers' compensation coverage. If you have an office employee, you have to have workers' compensation coverage. If you have no office employees and you usually self-perform everything yourself and you're a sole proprietor, you're just a, you know, a guy in his truck contractor, but sometimes you hire day laborers to help out for a day or two on some projects, well, you have to have workers' compensation coverage. Anybody who works for you besides a licensed subcontractor and their employees is your employee, and they have to be reported to your workers' compensation carrier. The payroll has to be reported, and you have to pay workers' compensation coverage for all your employees. Pay your premiums and don't miss renewals, obviously, on workers' comp. You know, another thing you can do to keep your workers' comp coverage and keep your rates low is keep the job site safe. I mean, safety is very important, and we really can't stress that enough in construction. So, you know, keep up with safety training requirements, have your tailgate meetings, provide your employees with proper PPE, and make sure your PPE is up to date. You know, I know electrical gloves need to be recertified, straps are only good for a certain amount of years, hard hats as well. So don't cheap out, and make sure your employees are protected on the job and minimize the risk of injury. If you make a mistake, fix it. Meaning, let's say you're a B contractor and you're doing a project and you got 24 different subs, and 6 months after the project is done, you find out that one of the subs has the same name as somebody who is licensed, and you thought they were licensed, but they weren't, and they were an unlicensed subcontractor. Well, go back, look at what you paid them for labor, report that to your workers' comp carrier, and pay the premium difference. If your workers' comp carrier audits you, make sure you share with them as much information as you have. Don't hold anything back. If you hired unlicensed subs, tell them. If they assess the premiums, work out a payment plan. The reason I stress this workers' compensation issue so much is I mean, it's pretty, you may have heard recently, local contractor here in Simi Valley was actually convicted of multiple felonies for underreporting his workers' compensation coverage, which I'm sure with that on his record, a civil court would be very likely to find that he was unlicensed as a result of this failure to maintain coverage. If any of his projects he worked on, if the owners were to sue, they would likely be able to recover all the money or get a judgment for all the money that that they paid him. So, because that's what we're seeing plaintiffs do these days. If they even get a hint that you might have hired unlicensed subs or you had employees that weren't covered by your workers' comp coverage, they tried the legal argument is that to have a license, you have to maintain workers' comp coverage. And if you have employees who aren't covered, then you're not maintaining coverage, which means your license is automatically suspended. Now, the courts can even go back retroactively and say, the CSLB might have never done anything. You might not have a citation, nothing. But if you get sued and the court looks and they see that you're fraudulently underreporting your payroll to your workers' comp carrier, then the court can say, well, 18 months ago when you worked on Mr. Smith's house, you were unlicensed, you have to pay back all the money Mr. Smith gave you. Even if there's no defects, there's absolutely nothing wrong with the project. When owners, if they find out that you're screwing up your workers' comp coverage, that's the avenue they're going to take, and they're going to argue to the court that because of that you were not licensed. Maintain general liability insurance. Again, not for individuals and sole proprietors, not necessarily a license requirement, but the advantages of having insurance coverage in the event of a dispute is just tremendous. So if there is a dispute and there is coverage, then the insurer should pay your defense costs, which would be my fees in a dispute, which a lot of times attorney's fees can quickly pass up the amount in controversy. You might be suing for 50 grand and it could cost 100 or 150 grand to take the case all the way to trial. So if or you might be getting sued, and if your insurance coverage is paying the defense costs, then you're in a better position in the litigation. It affects the strategy for litigation as well. If we don't have the budget to take 15 depositions, then we won't take 15 depositions. But if we have the insurance defense coverage and there's 15 recipient subcontractors and we need to find out what they know, then we'll be able to do that. And it changes the whole game in a dispute context if you have defense coverage. And then of course, if there is a judgment or if there's a finding of liability, the insurance, if it's other property that you damage, then the insurance company should pay the damages as well. So don't miss renewals, and then require proof of renewals from subcontractors. So we'll get into subcontracting a little bit more here. First thing, if you're hiring subcontractors, make sure they're licensed. Have a standard operating procedure for double checking the subcontractor's license status, and make sure they have insurance, both general liability and workers' comp coverage. And then we can actually, it's so easy to do this. We can do it real quick here. I'll pull up the CSLB's website and we go to consumers. Remember, the CSLB is a consumer protection agency. And we go license check, and we can just put in the contractor's license number. And we see the license detail, it's active, it expires to 28/23. See the classification, we see that they have a bond. We see their workers' comp history, they have coverage, effective 1/7. So if you're hiring this subcontractor and the project's going to be going on through February of next year or through January of next year, you want to make sure January 7th or a week before, January 1st rolls around, you ask the subcontractor for proof of renewal or proof of coverage for workers' compensation, because it's going to be expiring during the project. So you always want to check for all your subcontractors, check their license status, check their coverage. Make sure your subcontracts have appropriate insurance requirements and actually enforce them. So, typically if you're a general contractor, the owner, the prime contract is going to have extensive insurance requirements, and it's going to require you to have those same insurance requirements of your subcontractors. So you need to make sure that your subcontracts actually have the insurance requirements, and then you actually need to have an operating procedure in place to actually enforce them. Make sure that you're getting the COIs and additional insurance certificates from the subcontractors before they start working. And then we'll go back to the CSLB page real quick. Another thing you want to do is when you're checking their license, check the personnel list. Make sure that the person that you're dealing with has authority to bind the company. So here, this license, Jonathan Walters is the sole owner. And if I'm dealing with, Alexis Bryant or something, well, who's she? She's not on here. So I want to make sure that, whoever I'm dealing with has authority to bind the company. If it's a corporation, and when you click on the personnel list, you should see the president and CEO. I think any officers will also be on here, and it'll show who the RMO is, who's the license qualifier. So you want to make sure the person you're dealing with has authority to bind the subcontractor. So the consequences of hiring a subcontractor without a license, if they don't have a license, it's not likely they have workers' comp coverage. So if they have employees, or if they don't have a license, even if it's just a one guy solo operation, you hire, Bob Smith Painting, and it's just Bob Smith with a bucket and a paintbrush. If he's not licensed, if he's not a licensed painter, then he becomes your employee as a matter of law. So you have to report anything you paid to him to your workers' comp carrier's payroll. You have to pay the coverage. You might not have categories. If you're a B contractor, you're mostly a paper contractor, you probably have your office category, and then maybe you have your framing crew and carpentry crew, and you have framing and carpentry and office personnel. Those are the only categories of coverage you have on your policy. Well, now you just hired an unlicensed painter, so you're going to have to report the money paid to your carrier, and you might have to add additional categories of coverage. Some of the categories, it's like 50 cents on the dollar or more. For roofers or concrete foundation guys, it can get expensive. But you got to make sure you have the right coverage for your employees. And you got to make sure that you're not gaining employees that you didn't know about, because even if you have a licensed sub, if that sub, he might be licensed, but say he has on file with the CSLB a claimed exemption from workers' comp. He says, I don't have any employees, I'm exempt. Well, then he shows up on your job and he's got a crew of 4 guys. Well, those are your employees now, and you have to report that payroll to your workers' compensation carrier. Another thing, if you're hiring an unlicensed sub, they might not have general liability insurance. So issues could arise with that. If you're a B contractor, your insurance, there's probably only certain trades you're allowed to self-perform that'll be insured by your insurer under your policy. So if you go out and you hire an unlicensed or even uninsured foundation contractor or unlicensed, and then there's a problem with the foundation, and then you get sued, and then you tender to your insurer, and they say, well, hey, you're not supposed to self-perform foundation work. We're not covering that. So there's a lot of issues that can arise if you hire unlicensed and uninsured subcontractors. It's also called cause for disciplinary action with the CSLB. If the owner finds out you hired unlicensed subs, they can complain to the CSLB. CSLB can, issue a citation. They can suspend your license if they think that actions are bad enough, and they eventually could revoke your license if you have a pattern of unlawful activity. And then, worst case is the disgorgement penalty authorized by Business and Professions Code 7031B. And that would be if you hired unlicensed subs, you get sued, the owner shows that half the people on the job weren't covered by workers' comp, then the court can say that that's a failure to maintain coverage and find that you were unlicensed as a result of failing to maintain workers' compensation coverage. So finally, the best thing you can do to protect your license is do good work. Manage the project well, stand behind your work, fix punch list items, make the owners happy, and do good work. That's obviously the best thing you can do. These are obviously not an exhaustive list of causes for discipline, but these are things that I see pop up a lot. So abandoning a project, failure of the licensee or RMO to adequately oversee a project. So this can happen a lot. Some people think it's okay to quote unquote rent their license, where they get a skilled superintendent, but he doesn't have his own license, and they basically just have him do a whole job, and they never, the licensee or the RMO never actually, oversees anything, and they just put all their trust in this unlicensed superintendent. That can be cause for discipline as well. Deviating from industry standards and design, of course. This is another big one that we see happen a lot on residential projects. You're not allowed to charge more than 10% down payment or $1,000. So if the job's over 10 grand, it doesn't matter. Your maximum down payment is $1,000. If it's less than $10,000, then your down payment is going to be even smaller. Failing to use a home improvement contract that we looked at earlier with all the required disclosures and notices and attachments on residential projects can get you in trouble. Failing to maintain workers' comp coverage and using unlicensed subcontractors. There's lots of other things the CSLB can discipline you for, but these are the big ones that I see on the day-to-day basis with my clients and the opposing contractors that we come across. Manage the project funds. Misappropriating project funds is a crime. A few years ago, a local contractor was convicted of multiple accounts of diverting construction funds and also charging more than $1,000 on a home improvement contract. So it cost them a fair amount of money, and it was a jail sentence if he didn't pay the money. So likely paid that, but that's something you definitely don't want to do. So to manage your project funds, make sure you don't even inadvertently misappropriate funds. Here are several steps you can take. You can use a business bank account. Don't mix construction funds with personal money. Keep your receipts and paper copies to prove where the construction funds went. Don't borrow funds from one project to pay your subs on another project. And make sure your employees and payroll and everybody in-house is paid properly as well. And then at all costs avoid disputes. Disputes are costly. You get CSLB complaints. The CSLB will do their investigation. They can issue a citation, and you don't have the same rights to present evidence in your defense on a CSLB investigation as you would in court or arbitration. And the CSLB can take administrative action without a long drawn out trial. They can send an investigator. They can just look at your contract, and if it's a home improvement project, they can look at your contract and see that you didn't comply with the right to cancel or the right, the notice of the right to require a payment bond, that kind of thing. So they can issue a citation, with minimal investigation, and it's appealing it is you have a lot less process than you do in litigation. License bond claims. So invariably, anytime you have a dispute with someone, they're also going to make a claim against your license bond as well as you. And of course, your license bond, it's not a bank account. It's not 15 grand that they pay out. If anything, your license bond pays out, you're going to be required to reimburse your bond surety for that. You also have to pay your license bond sureties attorney's fees for any complaint that gets filed. So typically, a lot of times if you're getting sued and your bond surety is getting sued and you come to me and you say, Nate, I'm getting sued, I need you to represent me. Usually it'll be in your best interest to have us represent the bond surety as well, rather than having to reimburse whatever law firm they get for their defense costs. Because when we're working on your case, it's not too much more work to defend the bond surety at the same time. And then, litigation and arbitration, of course, very costly, especially if you don't have insurance coverage. You want to make sure, you have attorney's fees provisions in your contracts so that if there is a dispute and you're justified, and then we'll go to court and we'll win, and hopefully, and then you can be entitled to recover your attorney's fees as well if your contract provides for it. When you have a liability case and you come to me, I'm not the type of lawyer who's gonna, just see, churn the file and bill. I'm not gonna do that. If I think you're wrong and I think you owe money, I'm gonna tell you to settle it and bite the bullet and try to get it resolved, still costing you as little as possible. If I think it's a liability case, I'll advise as such. But either way, you want to avoid disputes at all costs, because once the lawyers get involved, everyone knows it just goes crazy with how much it costs to litigate a claim. So yeah, at the end, liability for contracting without a license, we've kind of gone over it here and there throughout, but you're prohibited from collecting any payments. So if you did $1 million job, you got paid half of it, and you want to sue for the other $500,000, you can't if you weren't licensed. And the owner can then sue you for the $500,000 that they did pay you and get that back if you're not licensed. So Wright v. Isaac, that was a case from about 15 years ago now, but that was, and I stressed workers' compensation a lot in this, and if you're wondering why, it's because that's what Wright v. Isaac held. It was the contractor had reported $312, not $312,000, $312 in payroll to his workers' comp carrier for a period where he actually had $135,000 in payroll. And then the court found a pattern of that. So they even though he had a policy, he had a workers' comp policy, because he was grossly and fraudulently underreporting the payroll, the court determined that that was a failure to maintain coverage. And of course, if you don't maintain coverage for your employees, then you also don't have a contractor's license. So here, I think the contractor had like 30 grand that he was seeking on his unpaid invoices. He ended up not being able to recover that, and then he had to return 60,000 for the other part of the project. And even on these numbers, it's a lot of money. But even there, back in 2007, he also, after he lost that, had to pay 90,000 in attorney's fees. So even there, the attorney's fees were higher than the amount in controversy. And so he ends up getting, hit with a judgment for almost a couple $100,000 over, a $30,000 unpaid invoice because he had been fraudulently underreporting his payroll to his carrier. So the consequences of not having a license are drastic. The way you cannot have a license that a lot of people neglect to pay attention to is if you don't maintain workers' comp coverage. So that would include coverage for unlicensed subcontractors, day laborers, anybody who works for you who is not covered by a licensed subcontractor's separate workers' comp policy is your employee. So if you can't avoid disputes and you do have liability and you get a judgment against you, it's important that you pay your debts. If a contractor has an unsatisfied judgment that's construction related, the CSLB will suspend the license after notice from the claimant. And this applies to any license that the qualifier is the qualifier for. So if you have a sole proprietorship and you're licensed individually, and then you're also a qualifier for 2 different corporations, let's say that you own 20% of, and then one of the corporations gets a judgment against it and it's construction related, then all 3 of your licenses will be suspended until that judgment is satisfied. So you can't just abandon or dissolve one corporation and say, okay, I'm and I'm going to do business under this one. It's not going to happen. The CSLB is going to suspend all licenses qualified by the person who was the qualifier during the dispute that gave rise to the judgment. What does construction-related judgment mean? It means pretty much anything you do as a contractor is construction-related. If you don't pay your employees properly and you get an employment lawsuit against you and you get a judgment for unpaid overtime or minimum wage violations, that's going to be considered construction-related. If the owner doesn't, is suing for fraudulent inducement to contract and you never even actually did any work on the project, but you entered the contract and then they're suing to rescind it, that's going to be construction related if you were to lose in that scenario. So pretty much anything you do as a licensed contractor is going to be construction related. So ultimately it's best to avoid disputes, but when you can't and you do have liability, it's important to pay your debts if you want to keep doing business as a contractor in California. So that, I think, is the end of my slideshow. I'll take questions. I do have a few questions. Okay, so the first question, do I need to use a formal contract for small projects? So I think I'm going to assume you mean residential projects. They're going to be, that's yes. Anything over $500 you need a contractor's license for. Anything you need a license for with the owner needs a written contract. And if it's a residential project, it has to have those 4 pages of attachments and another 3.5, 4 pages of mandatory disclosures, everything that's in that highlighted copy of the contract template, which will be available with the slideshow. Another question, what should I do if someone files a complaint about me to the CSLB? So the CSLB is going to reach out to you and they're going to ask for additional information. They're going to ask for the contract, basically your job file. At that point, you may want to consult an attorney before responding to the CSLB. With an attorney representing you, we can help formulate your response to the CSLB to make sure that they're getting the best evidence to minimize your potential liability. But if you don't get an attorney in that situation, you want to be as forthcoming with the CSLB as possible. You want to give them, it's better to overshare. If they ask for your contract and your invoices and you give them, all your backup and everything else too, great. It's better to overshare than to not respond to inquiries from the CSLB. But again, it'd be best to consult with an attorney before responding to the CSLB regarding the complaint. Were there any other questions? All right, well, I think that's it. I hope you guys benefited from this webinar, and if you have particular legal issues, I encourage you to consult with an attorney. Could be me, someone at our firm, another experienced construction attorney. My contact information is on the screen, 805-306-1100, and I'm at extension 126, and you can always shoot me an email as well. So thank you and have a great day.